It is Sunday, 19th of December 2020. It's about midday. My name is Aaron Hunt, a partner here at Stace Hammond, and we are back in the office. Thank goodness. It is good to be back. It's been 3 weeks since the last video. While I know we try to put out videos every time there is a major change to immigration, we haven't been able to do that. The end of the year for lawyers is typically the busiest time of the year, and on top of that we have the 21R visa, the 2021 residence visa. We're calling it the 21RV, just to make it nice and short. The website, of course, of the day the 21RV going live, and the website didn't go live. Well, it sort of died, and so many changes to immigration that we really should have been doing a video almost daily. We just haven't had a chance, unfortunately, despite working effectively daily for the last several months. So here I am, the final Sunday before Christmas, bringing you a bumper-filled video with immigration news that has occurred over the past 3 weeks, as well as looking forward to what's going to come in the next few months. But first of all, as always, this is not legal advice. This is just our commentary on immigration here in New Zealand. If you're looking for legal advice, please get in contact with us in the description down below. The details are there. Also, if you find this video of use, or any of the other videos of use, please like, share, subscribe, and if you can, there's a link in the description. Click on that, leave us a Google review. It really does help us to sort of boost our website flow through. Now, we are going to be covering a number of things today. We're going to cover the amendment circulars, going to be covering the, scrolling through my list here, 21RV, what are we on with that, and some changes, what we thought, and some few tips going forward for those who are applying. SMC Processing, the skilled market processing, onshore and offshore. 30 April 2022, what's happening then, and we're going to look finally at the High Court decision of the Afghan nationals, which has been some major changes there from that. But we're going to start with the amendment circulars. Now, the operational manual, we've mentioned many times before, if you've seen our videos, you'll hear about the operational manual all the time. That is the rules that Immigration New Zealand apply. You can look at the immigration website and there's a few pages on here that help you, but it's the operational manual that's the most important thing, and we'll link to that in the description down below. Now, if you hear me refer to at any point during this video, I'll do it a few times, a letter then a number, such as E3 or Y3 or H525 sort of thing. That is a reference to the operational manual. And I'll have a sequence. So say later on we'll go through E3 265C, that is section E3, then subsection 26, page 26, then subsection 5, and then point C. So you'll be able to go through and sort of follow where I'm looking at if you want to go look at it yourselves. Okay, so the amendment circulars, with the operational manual, they make changes to it fairly infrequently most of the time. Typically it was sort of once a month. And like, for example, in 2015 and 2016, there was 11 changes in each of those years, so 11 amendment circulars issued. In 2017 there was 14 amendment circulars. In 2018 there was 12 amendment circulars. And then in 2019 there was 15 amendment circulars, so it was sort of a busier year. Now last year we had 56. And on Friday we had our 60th for 2021. So the number of changes to the operational manual, well, the frequency of changes has gone up. Now, these amendment circulars, they get sent out to lawyers and advisors, and then a few days later they'll appear on the Immigration New Zealand website. I will link to the page that has them in the description down below. The amendment number 60, we got through on Friday. It's not showing on the website yet, but it will go up there, and then at some point in the next week or two, the changes will appear inside the actual operational manual itself. So the operational manual may not be the latest version because they'll have to apply these rules to it, but often when they release these amendment circulars, those are the rules when they get released. But it will say within the circular as to when that takes effect. So yeah, so we've had 5 in the past 3 weeks. Amendment 56, we actually won't cover now. We're going to cover that later because it relates to the High Court case, and there's a lot of detail involved in that amendment circular. So I want to sort of leave that till later. Actually, a quick point here. I will leave time codes for all the sections in the description down below, so you can jump to a section if you want to sort of go to a certain area of the video. Please watch as much as or little as you want. We make no money off you watching, so it is your choice. So 56 we'll look at later in this video because it relates to the High Court case. 57 came out on 13 November, and it was to provide some tweaks and fixes as to the 21 RV instructions. The day before they were due to come live on 1st of December. Now, most of these were obvious, and so no real change. They were sort of just little tweaks and clarifications based on questions people had about the process and the application itself. The only change here was an alteration to E3265C, the only change that we thought was notable, allowing for holders of visitor visas who are aged 18 or older, have left secondary school and were a dependent child in a 21 RV application, that they can be granted a variation of conditions to allow them to work 20 hours a week. So this is for kids who were stuck at home. They perhaps were part of an application for skilled migrants several years ago. It's still sitting in queue. They had finished high school. They couldn't get a work visa because they had no experience or qualifications, and they couldn't really afford to go to tertiary because international fees are ridiculous. So they were sitting at home doing nothing. So this allows, once the application for 21 RV had been made by their parents, they could go and apply for a variation to their visitor visa to allow them to do 20 hours a week of work. So something to allow them to go do something while it's being processed. Which is great. It would have been nice to see that without the need for a variation, that you could actually just had that. If that's you, your visitor visa now allows this, but instead they've gone for the approach you have to apply for the variation to let you do it. Now, Amendment 58 on 2 December, so a couple of days later, was the second change related to the High Court case. Now, we're going to mention the other change later on, but this one here we're going to detail a little bit now. This second change requires Immigration New Zealand to consider the border entry instructions when a residence visa application is submitted. So if you had a residence visa application submitted prior to the border closing, Immigration New Zealand needed to keep on working on your application. They weren't allowed to stop processing it when the border closed. Instead, they need to keep on going with what it was going. So when the minister basically said to immigration, stop processing these applications because they're offshore, it wasn't actually following the rules. He was ultra vires outside his rules, and the court have said you must continue this. Now, this leads to several significant changes. First, offshore visa applications that were submitted prior to the border closing must start to be processed again immediately. So all of you who have an SMC application sitting, waiting for allocation, I know there's a bunch of you because you see the comments from you, we've chatted in the comments of these videos. That is now changing, and your applications will start to get processed. Now, we hear that Immigration New Zealand is trying to work out how they're going to add them into the queue, but don't get too excited just yet. We're going to come actually to an SMC discussion later in this video where we're going to give you a bit more details about the figures and timings. Now, the second big change is actually two big changes they made to the Y330. Now, this is a section about who can be granted a right to enter New Zealand. So basically, it's New Zealand citizens and anybody listed in Y330 effectively has a right to enter the country. Now, Y330.14, under this amendment circular, it's a clarification there and you'll see why, states that the holder of a residence visa granted while outside New Zealand who applied before or on 30 November would be arriving into New Zealand for the first time as the holder of that visa, can enter New Zealand if they were allowed to do so when they applied. So we're talking about those who applied prior to the border closing. So I don't know why there's a 30 November 2021 allowance in there. It doesn't really make sense. We've talked before about how residence visas are strange in that they aren't really active until you've sort of been in the country on them. Well, now, if they've applied before the border closed and they would have been allowed to enter the country before the border closed, they can probably enter the country now under this change. So for those with applicants who are offshore, partners who are stuck offshore with the hope of a residence visa or having the offer of one there, your time may now have arrived. Now, the second big change is something that we have talked about before, and it's in an earlier amendment. They entered an allowance for holders of a 21 RV who were granted it as a dependent child for 25 years or older, that they could enter the country if they were granted the visa offshore. But there wasn't an allowance for anybody else in the family to come into New Zealand. It was just those adult children 25 years or above. Now, thanks to Julie Rayner over at the Immigration Boutique for providing me with a visa pack that clarified that partners offshore would be considered as having a visa based on partnership and could enter across the border on that basis. So it seemed that the inclusion of the adult children earlier was because they didn't fall under that visa pack. However, that circular changed. So this they had this earlier circular that allowed for these adults because they weren't included in the visa pack. But now the circular in Y33015 in this circular was to allow for anyone who was granted a 21RV when offshore. At the same time, it removed that allowance for the adult dependents. So now it was sort of expanding it from the adult dependent children to 25 or older to everyone who was granted it, despite a visa pack saying that really they can get into the country anyway. So I guess that they sort of realised that the rest of the family may want to come into the country and they wanted to clarify it. So they put that into the amendment circular, but it didn't stay that way because a week later on Amendment 59 on December the 9th, things got a little bit strange. Y330 was changed once again and they removed the whole need for a residence visa to have been applied for before 30 November because that was a ridiculous thing to put in there, as it made no difference. So now it was just basically a test that when they applied, would they be allowed to have border entry at the time they applied for their residence visa. But they also removed the allowance for family members under 21RV to enter the country. So they had originally just the adult 25-year-old children, then they changed it to all the family, and then they removed it altogether a week later. So it would appear that as of 9 December, partners who are offshore maybe can't enter New Zealand, but what about those who applied for 21RV before that date? And does the visa pack still have place there? No, were these changes to Y3 actually not needed because they were already in the visa pack? Or have they gone back on changed the rules again? We had clients who applied for 21RV in between 2 December and 9 December with family members who are offshore, and we're sort of saying, well, what rule applies here? We would say that the amendment pack that applied, which included all the family, and the visa pack was still there. But is that removal on 9th of December sort of a change? I assume with the High Court decision, they have to apply the rules that were in place when the person applied, which would say that, no, definitely the family can come in. We're going to try and get confirmation with Immigration in New Zealand on this, but with the frequent changes, we sort of think that they don't even know their own rules or how it actually applies. Or perhaps the Y330 addition of the family was a mistake. But if that was the case, then should they put back in the allowance for the 25-plus-year-old child because they're not put it in the application? They have their own application. So it's a bit of a mess there. So hopefully we'll get some clarity from that. I think when our clients go that way, we've asked Immigration for clarity on that because it's a bit of a mess. And then finally, December 17th, Amendment 60 that came through on Friday. Lots of small changes here. There were some tertiary student changes for the 1,000 students that are supposed to be coming in. We're still holding our breaths. Well, no, so not holding our breaths on that because we had 300 teachers coming in and none of those have arrived yet. There's an allowance there for Women's Rugby World Cup 2022 and the World Rugby Pack 4 tournament. There's a change to this is an interesting one here actually. There's a change to dairy farm assistants who there was an allowance for border entry granting of a work visa for 200 of them in total. Now they've changed this so that they now have to be earning at least $1 per hour above the median wage, where prior it was just the median wage for assistants. So there was a change there, and the applications for those are closing 30 April 2022. Not sure why that's being changed or why they've put in the $1 above median wage. I figure that right now, from what I hear from the industry, the farmers will happily pay $5 above the median wage just to get them in the country because there's just an absolute dire lack of staff out there. But for whatever reason, they have decided to add on $1 to the median wage, which is interesting because we actually haven't had an announcement of the median wage changes yet, which should be coming through at some point to $27.76, which is our call as to what it's going to be for next year. Okay, next section, 21RV, the 2021 residence visa, the one-off residence visa. Of course, many of these changes we've seen in the last month have been around this 21RV. We thought we'd go through our experiences, the stats coming out of INZ on the application, and a few things we've learnt about this. So, got a few points here. So, number one, we'll start with the mess that was the system. So, we were up and ready at 6 a.m. My staff and I, on 1 December, regional applications made. The actual system actually opened up an hour early, we found out. So, the first applications were already actually submitted prior to 6 a.m. So in the system actually opening, they'd actually been running and applications were being done. And then it collapsed. The system was so slow, extremely slow. Now the website, I saw actually a really good guy on one of the forums who's a website developer. He went through and read all the code and he said it's a very old-fashioned way of doing things. And it uses the logic where the page will update depending on what you click, and you probably would have noticed this when you've used it. So you're looking at a certain page, you click on a certain visa type, and then it will update the page to change to what they're asking of you. Now, whenever you do one of those clicks, it sends the information back to the server, which then tells the page what to change. So you'd click, wait, and something would take place. Problem was that the server was painfully slow that day, and that was we heard blaming third-party networking issues, that sort of thing. We think there is some element to that because we were doing it I was up at 3 in the morning trying to get stuff done before everybody else got on there, and it was still painfully slow. So I don't think it was a load issue. But what we'd see is that basically you would click, you'd wait, maybe something would appear, you'd start to enter it, and then it would decide that you've clicked on something else and it would remove those and do something else, or you'd lose like 2 or 3 steps. In the end, on that first day, with patience, we could perhaps get up through a page in 20 to 30 minutes per page. And they kept on working on it, and then in a day or two, they introduced a second method to enter applications. And this is a point 2 of our little list here. Now, we had mentioned a few months ago that Immigration New Zealand was going to be using a new system for these applications. The same system being used for CPVV applications, where you're not logging into a site, you just go to a page, you enter the details, you hit submit, and that's it. Then a few weeks ago, we heard that will be going back to the original system. And this was a surprise for us, as we told you that they were using the new system, and then they seemed to change their mind. Now, at the time, we thought it was a good decision. Actually, in the video, I say this is a good decision because we like that system, because you can log in, you can check things, you can upload your documents, that sort of stuff. But we were wrong. That system is not good. However, it does appear they have been working on a new system. So we weren't wrong in the new system, it's just that they decided at some point to go back to the old one. They'd changed their mind for some reason, and it was actually at some late stage that they changed their mind because it seemed the system was pretty much working. Because a couple of days into this whole mess of a situation, we got given a link to the new system that we can make applications through. And this went out to lawyers and advisors to use. And then a day later, others found out, and of course the link was shared around, and Immigration New Zealand officially sort of released it to everybody to use for applications. And we moved our applications from being on the old system onto the new one because it was just fundamentally faster. We returned to the old system once the old system was fixed because it is still, at least because we can go back and check things and add documents, and that was still a better option, especially when we were having applications where the SMC number was not working. We could get it sort of partially done, and then it would say, yeah, no, this code's not right. We could then save the application, get a new code for immigration, and then proceed. So the old system was good there, but it just wasn't good for a while. Once the old system was returned, they removed the new system, and things went back to how it should have been in the first place. Now, point number 3 here. Now, on 1 December, one application on that day did take 9 hours due to there being so much information to enter into the application, as the client was Chinese. And this comes down to the NSC, the security check, and the INZ 1209 form. Now, when Immigration New Zealand announced that they would not be requiring police certificates, for offshore applicants, for any applicant, sorry, I said that it would only work if they didn't instead move to doing NSCs on everybody. And for many, they haven't. Most notably Indian clients who we haven't been asked yet for a single NSC or INZ 1209. Yet some countries, it seems, that INZ have chosen that an NSC will be a default requirement. Now, from a legal point of view, we believe that such requests are outside of Immigration New Zealand's power. S6510 requires the applicants to provide sufficient evidence to demonstrate that they meet character requirements. Now, we don't believe that coming from a certain country means that character requirements are different. There's certainly no allowance for that in the operational manual. Now, Section 19 of the New Zealand Bill of Rights Act states that people have a right to be free from discrimination as defined under the Human Rights Act. And in that Act, under Section 21, that prohibits discrimination on the basis of ethnicity or national origins, which includes nationality and citizenship. So we can't see how choosing that people from some countries should be by default subject to NSC checks based solely on their nationality. That has to be discrimination. It wouldn't be such an issue if an NSC check was quick, but traditionally INZ won't chase it until it has been 6 months. That is a long time to wait, especially when you're seeing other people being granted residency within a few weeks. You're sitting there waiting for 6 months because you're Chinese, because you're Nigerian, because you're Russian, because you're one of these countries which immigration has said that because you're from that country we require an NSC for no other reason than you are from that country. So we'll be asking that question from Immigration New Zealand. We don't expect anyone to be complaining too loudly because you don't want to aggravate Immigration New Zealand, so we'll be doing that in your place, as we don't believe this is fair and we don't believe it's legal. Number 4, we've seen some documents falling off applications. Now, not many. This is an ongoing issue that does occur sometimes. So if you had an application and INZ come and ask for a document that you've already given to them in the application, just provide it again. Try to make the immigration officer's job as simple as possible. Don't say, hey, I provided that, go check your systems or check your other. Just provide the document again. It makes their job simpler and that just makes it better for you. Now, the numbers. We know that it can be hard to see people on Facebook being granted visas, and it just feels like everyone else is getting them except you. Just remember that all of those people who aren't being granted visas aren't posting to state that. So all you are seeing is the successes. And we are only a couple of weeks in, so a residence visa being granted in a couple of weeks is generally unheard of until now. In the first week, there was 9,500 applications submitted, totaling 21,500 people. In that week, 20 applications were approved and visas issued, covering just 26 people. Okay, so in week 2, December 8 to 14, there was 1,450, so 1,500 people applied, applications applied for 3,800 people. In that week, there was 77 applications approved for 108 people. So in that 2-week period, you've had 10,833 applications submitted and just 100 granted. So please just give the process time. Don't panic that you haven't got your visa yet and other people have. It is not a fast process generally, and a couple of weeks is extremely quick and surprising. And now just a couple of quick tips. Don't try to overcomplicate it. We saw people posting crazy things that they couldn't believe it was that simple, trying to make it more complicated than it was. We've covered this in videos before. Don't try to overcomplicate it. It is what it is. Now, when you're doing the application, just because it lists something, it may not be required. One example is if you're applying for settled criteria, it gives you an option to upload documents for your job, but it isn't a compulsory field as it hasn't got a red star next to it. So you can leave that blank because you're applying for settled unless there's a requirement for you to provide it or a reason for you to provide it. The same goes for partners who currently hold a visa based on partnership. There is a field there to provide evidence, not required. The only field that is required is there is a field requirement for to show relationships. In that case, for our clients, we've sent through birth certificates, marriage certificate, just to sort of show as to how the parents link and how the parent links with the children, and that's basically been that way we've approached that. If your partner hasn't got a partnership visa, then you're going to provide the usual living together requirements or the other factors. And finally, Final point here is that the INZ team are dedicated. Just this morning, and this is a Sunday morning, one of our clients got their residence visa approved and issued. It's common to see the immigration staff working on weekends, on Saturdays, on Sundays. It also isn't unusual for them to see them working over the Christmas New Year break. So when many companies close down, we'll still see a lot of them continuing to work. So don't think that they're going to go on holiday for several weeks, because generally they don't. They will have a holiday at some point because, well, fair enough. But yeah, don't panic because you think it's going to be a few weeks wasted. Many of them will keep working. They do a very hard job, and they're doing a great job most of the time. And on that note, I just wanted to mention that we will be working as well through this break. There's a lot of immigration issues get raised during this period, so we do continue to work through this period. So if you do have any urgent matters coming up, you can get in contact with us. We'll happily help you out. You can engage us to assist. So please just always remember that we are here to help. Okay, we wanted to touch on SMC processing, skilled migrant category processing. We were asked a number of times about people waiting whether they should move from SMC onto the new 21RV visa. And in most cases, generally, it was a yes, as we believed that Immigration New Zealand was going to put a lot of people onto 21RV away from SMC, and we were right about that. INZ have confirmed that of the 70 plus staff who were previously handling SMC applications, only about 10 remain. The rest have gone to 21RV. I've also seen a number of officers from other teams, such as those handling essential skills work visas, also being moved across to 21RV. We've had applications, our clients, whose application has basically been offloaded to somebody else because the person's been moved to the 21RV team. This is what we sort of expected to take place, and why 21RV will be much, much faster than SMC applications. Now, we mentioned before that about the change due to the High Court decision that we're going to talk about later in this video, that requires applications made before the border being closed to be processed. This means that the 1,489 offshore applications now have to be processed as well. Now, we don't know how they're going to prioritise these. We expect that INZ is going to need to allocate those before newer NZ-based applications because they were made earlier. So once again, but of course we're only going to have about 10 staff actually working on those applications. So that's not going to make those applications much faster. At least they'll be actually going somewhere now. But we still believe that for those who are onshore, for the vast majority and only with very few exceptions, 21RV will be the faster way to go rather than skilled migrant. If you haven't done the 21RV already and you're on a skilled migrant application, you should be at least considering it. Now we wanted to have a quick discussion regarding 30 April 2022. We wanted to sort of clarify some of the government's announcements about the opening of New Zealand early next year. Now, we touched on it previously, but we wanted to just clarify it because we've seen a lot of people, I think, getting their hopes up or taking more out of the announcement than actually was probably there. Now, 30 April 2022 is not when the border is opening. The announcements that related to 30 April 2022, these were regarding MIQ and the plans for what was going to be required for people coming to the country in regards to isolation, how that was going to work. The idea was that from 30 April 2022, those who were vaccinated with a right to enter New Zealand could do so without doing MIQ. There'd be some sort of home-based MIQ perhaps and testing, that sort of thing. However, it's about those who have a right to enter. It doesn't mean that people will be able to apply to enter or be granted a right to enter. We do expect that we will start seeing visa waiver countries coming in at perhaps that point. Australia may come in first, they may add to that later on because Australia is not actually a visa waiver country, that's a different category. But it isn't going to be an open border and isn't going to mean that their applications are going to be granted. As of right now, August 2022 is when applications from offshore people are on hold until that date. However, and maybe for those that already hold a visa, like those post-study work visa holders who are stuck offshore, you may be able to enter from that date because you have a right to enter the country if that border opening does open up. it's one of those things where immigration needs to provide, or must need to provide more clarity on that, but we would expect that, we would hope that before visa waivers countries are allowed in, or at the same time, the post-study work visa holders who are stuck offshore, the essential skills work visa holders who are stuck offshore and who still have valid visas, time when their visas left, should be allowed into the country before or at the same time. So when they do open the border, when they do the changes in 30 April, if they take place, of course Omicron is changing how that's, possibly the situation there, we would hope that that would include those post-study and essential skills work visa holders who are stuck offshore. We'll have to wait and see what they do there, but it isn't going to be just borders open, let's make applications. That's highly unlikely. Okay, now finally, we're going to touch on the Afghan Nationals High Court decision. We're going to go through a few quotes from the court and how this applies mostly around the humanitarian criteria. It has created several amendments we mentioned before. Now the basic facts, and this is very basically the facts, there's a lot more detail than this, is that several Afghan nationals who had connections with the New Zealand Defence Force, assisting them, or the family had assisted the New Zealand Defence Force interpretation, that sort of thing, had made applications for residence before the border closed. Now, every indication was these visas were going to be granted. There was no question there as to the eligibility for residence. They were going to be granted. That was not in question. But when the border closed, of course, Immigration New Zealand stopped processing these visas. The Afghan nationals took the decision to court seeking an injunction. That was in August this year. And at that point, the court didn't allow that sort of instant order, but there was notes at that point that the Afghan nationals could apply for a critical purpose visitor visa under humanitarian grounds to get them out of Afghanistan quickly, because this has been, of course, the troops were pulling out and the Taliban was taking control again. So they tried this and they failed. They got declined. The court, in the most recent decision, heard full arguments from both sides, but was now looking at two factors. First, of course, they had the point about immigration stopping processing of the residence visas and whether that was lawful. But they're also looking at whether the humanitarian applications were handled correctly. Now, as you mentioned before, with the amendment circulars, the High Court found that INZ could not stop processing these applications. They must keep processing because they must be handled with the rules in place when the applications were made, which was before the border entry changes were made. The law was clear that the application is to be judged on the law at the time of the application. The Minister cannot decide that these applications would be stopped without a change in law. Now, the Minister had been granted additional powers under new legislation to do with the border during COVID. But these powers can only be used for positive things such as extending visas. They don't allow him to take negative actions like telling Immigration New Zealand to stop processing applications. Of course, this also calls into question, once again, the 50,000 applications that were lapsed by Immigration New Zealand earlier this year at the request of the Minister, and whether this was lawful, whether this was beyond his power. We haven't seen any legislation yet that would actually allow him to do that. But we expect there's going to be questions raised about that, as we've raised questions about it already, and stating, well, could he actually do that? Was it within his rights? Now, the second big outcome of the High Court matter was in relation to the humanitarian applications for border exceptions. Now, we've submitted a lot of these for our clients during the last 18 months, and we've got some granted. For those that do get declined, we always get the same useless response back, and that states, INZ were not satisfied that it met the criteria to be granted an exception to the current border closures on the basis of exceptional humanitarian circumstance. That's it. It never gave any sort of real detail as to why it didn't meet the criteria or how they were applying the criteria. And INZ was probably likely aware that there wasn't really much scope to challenge it without any real great cost. We couldn't do a sort of internal appeal. We had to sort of go to court and do a judicial review, which was going to be expensive, and until now it really wasn't done. There is case law, most notably Yi and the Ministry of Immigration. It was a Supreme Court matter which sort of determined what that humanitarian and exceptional circumstances, what that actually meant. But we never had details about how it was being applied to the CPVV applications under humanitarian circumstances until now. This is what this case provided. So perhaps knowing that the Afghan nationals were seeking it after seeking an injunction, the response from Immigration New Zealand to their application was a lot more detailed than anything we had had. INZ stated that the wording of the humanitarian test in restricted temporary entry instructions requires exceptional circumstances of humanitarian nature. That basically it goes on for a paragraph of more detail, but actually no real detail. It was how you expand a one line to 5 lines without providing anything really more. And Judge Cook commented that there was not altogether clear on what the interpretation had been. So even he was sort of questioning how it was being done. He said he had suspicions that INZ was trying to say that people whose lives were in danger in Afghanistan, because of their association with the New Zealand Defence Force, were not in a situation that was exceptional on a humanitarian kind. And this surprised the Honourable Judge, and I think it surprised many of us. Further clarity was provided by Immigration New Zealand, and this is where things start to become clear. Now, INZ's National Manager, Community of Border and Visa Operations, stated that INZ's approach to the H5 3025, which is the part of the border exception rules under immigration operational manual, is based on the requirement that the individual must have exceptional circumstances that make it strongly desirable for the person to travel to and enter New Zealand, as opposed to any other country in the world. Having an extended family member living in New Zealand is also not in and of itself considered sufficient grounds for approval. The CPV applications that have been approved under humanitarian category have often involved situations such as a New Zealand family member needing the physical or emotional support of the applicant. Examples due to family death or terminal illness. Cook J interpreted this quite rightly in that INZ was looking at only humanitarian circumstances that arose in New Zealand. So any exceptional circumstances that arose offshore would not be considered. This view was confirmed from Immigration New Zealand in a calibration meeting on 19th of August, in which they stated that the focus remains on the need to travel into New Zealand for a humanitarian purpose that exists here. So Cook J was quite right in stating that was quite right in his view, and he said that INZ's approach was erroneous. He stated that the Supreme Court decision of Ye and Minister provided a test which needed to be followed, but that this does not mean that humanitarian circumstances must only arise in New Zealand. So the application of humanitarian circumstances had been incorrectly applied for the past 18 months, because this appears to be the way they were applying all of these tests for all the people who have situations outside New Zealand that were exceptional circumstances of a humanitarian basis. Now, as they would never give details, it took a High Court judge to review to actually get this information out of immigration as to how they were doing this. Now, we've since passed this to the Ombudsman, who is handling a complaint that we've raised with them regarding the handling of humanitarian applications under CPVV. And we hope that this is going to be helpful with the Ombudsman to give a determination as to perhaps they've been handling this incorrectly for a long, long time. But this then leads us back to the start of this video, into Amendment 56, the first of the 5 amendments we're going to cover today. Up until now, INZ has been misapplying the rules that appeared under H5 3025, at least according to the judge. They were misapplying the rules. Now, soon after this decision was made, INZ changed the rules. The opening blurb for Amendment 56 states, changes have been made to immigration instructions to better reflect the government's policy on people who are allowed to travel to New Zealand while there are border restrictions. The compassionate entry exception criteria sets out exceptional family and medical related reasons for travel and confirms that a humanitarian crisis occurring outside of New Zealand is not relevant to the determination of a request to travel to New Zealand. So it states that this is a government policy, which we only assume comes from the Minister, that any crisis outside New Zealand is not a relevant factor to a request to come to New Zealand. Now, the court has determined that the law allows for exceptional circumstances based on humanitarian crises that are occurring outside New Zealand, but instead of following the court, the Minister changed the rules. So to those of people who are living offshore whose lives are at risk because you or your family gave help to our New Zealand Defence Force, instead of seeking to help you, the Minister just closed the door. This kind of government we hear so much of just turned its back on those who helped our own soldiers and military. Yeah. And that is where we're going to leave today's video. It's been long enough, I think, and probably the last one for the year. Unless something big happens in the next 2 weeks, this will be our last video for 2021. And let's hope 2022 is better than the last 2 years have been. As always, I want you all to have a safe and hopefully happy Christmas. Hopefully lots of you get your residence visas. Hopefully humanitarian applications start sorting themselves out and the Ombudsman can hopefully help us there. Until we see you all again, kia kaha and stay safe.